its papers, the MK party alleges a number of things. Firstly, it alleges that there is 9,338,833 unaccounted for votes that they need an explanation for as to what happened with these votes, and that's one of the questions they had asked the IEC. Secondly, the MK claims that there has been major discrepancies in result slips reflecting a different number from what the dashboard ultimately reflected as far as vote counting had taken place. This despite the IEC having ordered recounts where such discrepancies did happen at least 24 voting districts throughout the vote counting period. And lastly, the MK party says that they have commissioned a technical study and report on the IEC election system, particularly to ask whether the IEC have the technical expertise and readiness to execute a free and fair election. Legal analyst Mpumelelo Zikalala now joins me to unpack this a little bit further. Mpumelelo, perhaps to start here, the law of evidence is quite clear on what the threshold for sufficient evidence is, but there's a particular threshold, a different burden of proof when it comes to election evidence and the results there too. Should there be discrepancies, that does not automatically mean that the election was not free and fair, only if in an instance where it reaches discrepancies that makes a material difference. Can you describe to us what the threshold for material differences and material impact looks like as far as the evidentiary burden is concerned in this dispute?
Good afternoon to you and also to your viewers. You are quite correct. Maybe there's two things that you should note. Firstly, because it is a civil matter, it is on a balance of probabilities. So you just have to persuade the court that there is some inefficiencies that have taken place. But then you go back to the Electoral Act, which is very clear. It says that there must be a material irregularity. That means if taken from the votes that I'm alleging that were supposed to go to me as party X and they were given to party Y, if I get them back, maybe, for example, I'll get an extra seat or an extra 2 seats, and you must go and make those amendments so that I'm able to represent or to get my proportional representation as carried out in the voting that has taken place. Now, it is up to you as the person who's alleging. He who alleges must prove that these are the things that have taken place. So the manner in which you're going to do that, you're going to say, here are my party agents, here are my party slips, I've made the following submissions to the commission. They've rejected me, and now I'm taking the matter over to the electoral court. And if you go and you see what's happening there, that's the results in which you're going to get. Which is why, by the way, even the ballots that were cast are not thrown away. They are kept in a safe place so that if you want them to be recounted, you can easily go and do that. That ought to have been, in my humble opinion, part of the order that was requested, or ought to be requested by the MK party to say, here's a irregularity that has taken place. Can you please reorder that they recount this particular vote when we are present and we have even our legal representative being there so that you could be able to compute and detail what has been captured. Secondly, when it comes to the software or system which was utilized, show us the integrity report of that system so that you can be rest assured that it was okay and the various testing measures that were there. However, if I'm going to allege that there's something wrong with the system, I'm the alleger. I must be able to prove that there was something wrong. Otherwise, your application is not going to succeed. But the most important part, or two parts, is it a material irregularity? That's the first one. Secondly, in the order that you are seeking, it's impossible for you to ask the electoral court to say that the re-elections must start again. They don't have those powers.
Yeah. So the MK claims that 9.3 million votes remain unaccounted for. Here's how they got to that number. They say that if you break down every province into its regions and municipal demarcations, every municipality in this demarcation, if you add up the number of votes casted over there, it must add up to the number of votes counted across the province entirety. They say that doesn't seem to be the case in this instance, and so the difference thereof they add up as a discrepancy. They've added up a number of discrepancies by also subtracting the number of registered voters in each province versus the number of votes ultimately cast, and of course the cumulative effect of the votes that were cast in each municipality. Now, this is nowhere in their evidence do they make any room and and add into the equation of calculation the difference that could have been added by spoiled ballots and spoiled votes, as well as the number of registered voters in a province who voted outside of that particular province, which is also allowed in this instance. Those things cumulatively would make a calculation difference there. And of course, we don't know yet because the IEC hasn't yet given us that report. They have some time to be able to present that report, and they typically present it to Parliament once Parliament is properly constituted and has gotten into the rhythm of its business. Does this suffice as far as the evidentiary burden is concerned?
Not necessarily, because you're going to have a problem trying to prove those things. Remember, whoever has deposited affidavit, either they'll have to come back and say, I'm an expert when it comes to counting. This is how things are supposed to be done, and this is how things have been, and this is what we have experienced. Secondly, we are dealing with the result slips that were submitted by individuals. I have not seen the entirety of the papers. Maybe there are confirmatory affidavits from the individuals that were submitting the slips. Maybe there are confirmatory affidavits from the party agents that were there. But if you don't have that, then on a procedural basis, you're going to have a huge problem in terms of trying to persuade the court to believe you in the things in which you're alleging. So, at least if it was a situation where you go ward or voting station by voting station, and you say in eThekwini Ward 101, you had a voting station which was here and here, these are the discrepancies that have taken place. We've accumulated from the province of KwaZulu-Natal and all the other 8 provinces, and this is what you are finding. So the first order in which we are looking for, because we cannot declare elections or state that they start again, there's no provision that allows for that. At least allow us for a provision or an order that's going to say, go and recount IEC, now recount in front of us, so that you can be able to prove that what we are telling you is indeed true, or you can see who's lying between the two of us. If you don't go that route and you try and pin the court into providing an order that is impossible in order for the court to give out, that's when you're going to have a problem, and that's where your case may fail.
Yeah, I want us to take a look at this graphic here that gives a provincial breakdown of the MK's claim of unaccounted for votes per each province. And what stands out for me is our number of provinces. The Gauteng province, the MK claims there are 2.1, almost 2.2 million unaccounted for votes. In the Northwest, they claim that 1.27 million votes went unaccounted for. In KwaZulu-Natal, it claims, and this is where it is the leading party as far as the vote count is concerned, the MK party claims that 1.9, almost 2 million votes in KwaZulu-Natal are unaccounted for, and that in the Western Cape and in Limpopo, cumulatively 2.3 million votes there are unaccounted for. But Mpumelelo, perhaps to ask this again, not to be pedantic about the law of evidence here, but the evidentiary burden is quite clear that you must present positive evidence and not negative evidence. The distinction there is positive evidence is where you say, here is proof of an action having taken place, rather than saying, hey, these things are not adding up. There is something that's not explained. Therefore, there is a discrepancy that results in the election results not being free, fair, and that it has certainly been contaminated. The MK party seems to be asking questions with their every evidentiary submission rather than giving answers. Is that going to have a tough time passing in court, or is there real jurisprudence that enables such type of evidence to be submitted?
Well, there's no jurisprudence that allows for that. However, it may be a technical strategy from their side to say, we do not have those resources because we're not inside the IEC offices when they're counting. However, if we reverse the question and send it over to them and accuse them of lying, in their defense, that is when they're going to produce the evidence that you are looking for. And that's when they're going to produce the evidence that we think is going to assist us or is going to be in our favor. But the danger in doing that is that the response from the IEC may be, well, you have stated all these things, you have not attached any evidence that I can be able to discredit. So on those bases, I'm simply going to deny those things and say, on a burden of proof that you're supposed to provide me, unfortunately, I can't answer on what you've stated. So then the case is going to fall flat, and you're not going to be able to prove your case. I think what the MK maybe ought to have done is to say, let's go and concentrate more on a forensic investigation into the elections. and make sure that you
Can I pause you there, Mpumelelo, because it seems like that's exactly what they had attempted at doing. The MK commissioned a technical study and report on the IEC's election system, and of course this is a forensics report to some extent, but even again there it seems to ask more questions than it does answer about the technical expertise and readiness of the IEC. Again, the IEC has gone through these technical assessments by analysts and forensics analysts, to be specific, year after year, election after election. What are the chances that for the very first time they certainly don't have the technical expertise?
I think the chances are quite slim, and even if those reports will come back and say there are irregularities that have taken place, the most important question is, are those irregularities material or not? If they're not, then it doesn't serve any purpose. But if they are, then let's go to the second step. In which part of the province are we then concentrating on? In which part of the voting district are we then concentrating on? Is it going to have any change in the number of seats, for example, that the MK has in any provincial legislature? Is it going to have an impact in the number of seats that they have in a National Assembly? If the answer to that is no, then it means they may have something to cry about or maybe to complain about, but it is not material enough for a re-election then to take place. Even if that was the case, if you look at Section 55 of the Electoral Act, it says you can go ahead and declare those elections IEC, there's no problem. And then the most important one, Section 56, is the relief that is the Electoral Court can then issue. There's nothing that talks about re-election, but what it talks about is
just 30 seconds on this. One last argument that I think is important that the MK party makes is an argument pertaining to the elections counting process. The MK says they think it's problematic that party agents and observers only participate in that process up until the signing of the election results slip. Yet there are several other processes that take place after that election party agents as well as observers are not a part of, and that ultimately means that there are discrepancies between what appears to be on the election dashboard results versus the election slip that has been signed. One can understand why that is problematic, because it means that the rest of that process isn't subjected to the same level of vigilance and scrutiny.
They are correct on that one. However, the manner in which of trying to correct this is wrong. Because what you then must do, you must then say, let's amend the Electoral Act so that party agents follow the process up until the end. And the only way you can do that is to go to Parliament as legislatures, amend the Electoral Act and make sure that there's a provision that speaks to that. It is much as a provision that speaks to party agents.
Yeah.
And then be able to solve whatever that you are looking for. You cannot solve it by launching this application as they've done now.
Mpumelelo Zikalala, who's a legal analyst, thank you so much for your time and your insights this evening.